All in the court, please rise. You may be seated.
Good morning and welcome to the 45th Nuremberg trial simulation. I am Chief Justice Reese Benford, representing the United States of America. We are gathered here today to deliver 6 cases and deliver 6 verdicts for defendant Hermann Goering, Walter von Schirach, Karl Dönitz, Rudolf Hess, Eric Rader, and Julius Streicher, along with decisions regarding the motion on behalf of all defense and the prosecution motion regarding the criminality of the Schutzstaffel. Today's trial is not a recreation of the International Military Tribunal, nor are the verdicts likely to be identical, because the evidence presented is specific to our tribunal only. The unique evidentiary status of each defendant's case has been constructed for and against the defendants by the defense and prosecution, and the final judgments reached will be made without bias from the tribunal. Each country represented in this tribunal will deliberate the fate of each defendant by both engaging the law of their country and by invoking provisions of international law along with their country's judicial system. The justices have read the evidence brief prior to today's tribunal and are thoroughly familiar with the cases presented, their facts, and the legal positions that each party is advocating. After considering and consolidating all evidence and presented information, as well as the defendant's statements and their response to direct and cross-examination, all justices sitting in this room today will provide the court with a comprehensive verdict. The charter of the International Military Tribunal will be used to conduct a fair trial in order to afford the defendants and prosecution certain rights, such as the right to present evidence and speak to witnesses in their own defense, along with the right to cross-examine witnesses for the prosecution. As you will see, the German involvement in harmful warfare violates international treaties and laws, which calls for the necessary international judicial involvement. In 1943, Foreign Secretaries of the United States, Soviet Union, and the United Kingdom instructed the Axis powers to discontinue all aggressive warfare or justice would be served. Leaders of the Axis chose to ignore the warnings of the Moscow Declaration, so the defendants here today are brought in to face the consequences. The Allied countries met in London in 1945 to establish this tribunal and procedures to govern this international proceeding. As the final arbiters of the law, we justices have the ability to judge the guilt or innocence of defendants and shall provide the reasons on which our judgment is based, as well as refuse any challenges to our authority. The tribunal shall also have the right to impose upon a defendant on conviction, death, or other punishment determined as just. Following introductory remarks by my fellow justices, our IMT court resumes with the final arguments from lead prosecutor Miguel Fernandez and lead defense Coco Schuster. The proceedings of each case shall take place in an organized fashion, beginning with the prosecution and defense delivering an opening statement, followed by a final plea from the defendant in time for cross-examination on both sides. And finally, the court will be presented with closing arguments from both the prosecution and the defense. As mentioned by the charter of the IMT, the tribunal has the power to try and punish persons who, acting in the interests of the European Axis countries, bear individual responsibility for any crimes within the criteria for the following indictments. Count 1, conspiracy. Count 2, crimes against the peace. Count 3, war crimes. And count 4, crimes against humanity. The tribunal asks that you recognize the importance of this trial as the alleged crimes are rooted in racial hatred, violence, and the arrogance and cruelty of power. The Nazi government had no regard for any efforts to avoid aggressive warfare after World War I. We hope that this trial can help root out the hate and terror left by the acts committed throughout the course of World War II, which has left a blemish on the universe. I now welcome Associate Chief Justice Lauren Altman to speak on behalf of the United States of America.
Good morning. I am Associate Chief Justice Lauren Altman, and I'm here today to represent the United States of America, along with Chief Justice Reese Benford and Justice Kinsey Irwin. The United States is participating in the trials here today to bring justice to defendants found guilty of any of these 4 charges: conspiracy, crimes against the peace, war crimes, and crimes against humanity. For a while, the United States was not involved in the war, which began on September 1st, 1939, because of the tripartite pact. However, Germany supported the attacks that were launched by the Japanese on the United States. After Japan bombed the US fleet in Pearl Harbor on December 7, 1941, Germany declared war on the United States. Consequently, the United States came to join other allies in fighting Nazi aggression and joined them in the Moscow Declaration of 1943, which restated the Allies' resolve to continue the hostilities against those Axis powers with which they were at war until those powers agreed to an unconditional surrender, however long it took. In addition, on behalf of the 32 countries of the United Nations, the leaders of the United States, USSR, and United Kingdom signed a statement that warned those committing atrocities that they would be brought to trial once the war could be ended. In 1945, the London Agreement set up the International Military Tribunal, which begins its hearings today. The United States is committed to a fair trial for those individuals who have been indicted. The United States believes that the burden falls on the prosecution and presumes defendants present here today are innocent until proven guilty. Thank you.
The court will now hear from one of the justices representing the Provisional Government of France, Ms. Ahmed, to describe why her country felt it was important to have representation at this trial.
Bonjour à tous. Je m'appelle Justice Lisa Ahmed et je suis ici aujourd'hui pour représenter le gouvernement provisoire avec associé chef justice Stella Harris. France was at its lowest and bore the treatment of the Nazi Party in the months of May and June 1940. The Nazi Party led to chaos for our government and completely destroyed it, leaving it in the state it is in today. From June of 1940 to the summer of 1941, France had been occupied by Germany. The Nazi Party began implementing the anti-Jewish policies that allowed them to lay down the majority of anti-Jewish legislation in France during the first year of occupation. From there, segregation began. From August of 1940, citizens started getting deported and moved to the Reich to serve their sentences from prison. From the summer of 1941 to the autumn of 1942, the hostage issue arose and the final solution was being planned and executed. The final solution, which was discussed at the Wannsee Conference, was a plan that would wipe out Jews once and for all. The Jews in France were not at all safe. Even after the big plan of the final solution, there was still mass deportation and an escalation in violence from September of 1943 to the summer of 1944. The end of the occupation happened from August to November of 1944. Concentration camps such as the Drancy were liberated, finally letting France rest. Since France is so close to Germany, we were occupied fairly quickly, but we joined the Allied powers and did everything we could to fight to protect our country and those who were being wrongfully treated due to this war. France had been conquered twice in 30 years in the course of both wars. However, although we were temporarily overwhelmed by the numbers, material, and preparation that Germany had set against us, we never gave up our fight for freedom and are now here today to demand justice for what was done to our people and to the world. France believes that the burden of proof falls upon the defense, and we believe that there can be no peace and no progression for humanity without a proper tribunal where the heinous acts that were committed are taken seriously. Thank you.
The court will now hear from one of the justices representing the government of the United Kingdom, Ava Horwitz, to describe why her country felt it was important to have representation at this trial.
Good morning. My name is Justice Ava Horowitz, and I'm representing Great Britain along with Justice Charlie Leonard and Chief Justice Sophie Schermacher. The period starting September 7th, 1940 and continuing through the next 8 months was one of the darkest times in the history of the United Kingdom. 43,500 lives were due to the Nazis bombing our cities and towns in a plan to take our land and our pride. By the end of what was called the Blitz, 18,000 tons of bombs had sporadically hit our land, and terror spread throughout our once beautiful Great Britain. 1 in every 6 citizens of London became homeless, and millions of homes and properties were destroyed by the Luftwaffe. Hitler and the Luftwaffe tried to break the morale of our people so they could pressure our government to surrender our land, but they ultimately failed. In 1941, after the bombing of Pearl Harbor, the United States partnered with us to make it a priority to fight Germany. A decision to continue fighting Germany with the United States was established by the Moscow Declaration in 1943. Although we won the Battle of Britain thanks to the help of our allies, we lost too many innocent souls during the war. Originally, our government leaders, particularly our Prime Minister Winston Churchill, proposed that top Nazi leaders captured by the Allies be shot in order to obtain some form of justice. No trial was needed to prove that Nazi war criminals were guilty, for our cities were firsthand proofs of the crimes that had been committed. But after further reconsideration of how to punish Nazi war criminals, and after multiple meetings with US President Roosevelt and Soviet leader Joseph Stalin, we came to the agreement that an international proceeding at Nuremberg was for the greater good of not just our nation, but the world. We trusted the decision-making of our other allies, especially the United States, because they played a major role in winning not just the Battle of Britain, but the whole war. Ultimately, we have joined these trials to ensure that the world's humanity would always be protected by the law, and to guarantee that no one was above the law, including leaders of sovereign countries. The United Kingdom has determined that the burden of proof falls on the prosecution, for our legal system holds individuals accountable for their actions as opposed to solely their nations. We are here in hope that the Nuremberg trials will prevent future tragedies such as the ones that have been occurring in these last 6 years and took an immense number of lives and demolished our world. The United Kingdom strongly believes these trials need to happen to provide a sense of security within people and to restore hope in humanity that was destroyed along with our buildings and our cities. The court will now hear from one of the justices representing the federal government of the Soviet Union, Ula Chacho, to describe why her country felt it was important to have representation at this trial.
Good morning. My name is Justice Ula Chacho, and I'm here today to represent the Union of Soviet Socialist Republics, along with Justice Rogan McClendon. I'm seeking justice by holding Nazi leaders accountable for their heinous and horrific actions committed during the war. On August 23, 1939, our Foreign Minister Molotov and the Foreign Minister of the Nazi government Ribbentrop signed the Non-Aggression Pact. The purpose of the pact was to strengthen the cause of peace between the USSR and Germany. The government of the German Reich agreed to stay at peace with the USSR and not wage war. The German ambassador in Moscow informed Germany that the USSR would only go to war with Germany if they attacked first. The statement was recorded in the German War Diary under the date of June 6, 1941. During the end of summer 1940, Germany began to prepare for an attack against the USSR, disregarding the Non-Aggression Pact. This operation was labeled under the code name Case Barbarossa. The plan was finished by November 1940. On December 18, 1940, Hitler issued Directive Number 21, which called for the completion of all preparations connected to Case Barbarossa to be final by May 15, 1941. On June 22, 1941, without any declaration, Germany invaded Soviet territory as planned. Germany carefully and meticulously planned out their attack on the USSR to expand its borders eastward. The attacks in the USSR were created on July 16, 1941, and the final aims of the attack on the Soviet Union were formulated at a conference with Hitler on July 16, 1941. Between 1941 and 1945, Germany killed nearly 20 million Soviet citizens, 6 million civilians, and nearly 4 million prisoners of war, and 10 million were killed in the military. The horribly cruel punishments that the citizens of the USSR experienced during the war has brought the country to anger and despair. Because of all that was stated, the USSR joined the Allies in the fight to defeat the Nazis and proceeded to join the Allies in the quest for justice at Nuremberg. We want to hold those accountable who were responsible for the crimes committed. In keeping with the judicial practice in the USSR, we place the burden of proof on the defense.
The court now recognizes Stella Harris, Associate Chief Justice, representing the Provisional Government of France and justifying Count 1 conspiracy, for which the defendants may be tried for today.
Good morning. My name is Associate Chief Justice Stella Harris, and I am representing France along with Justice Nissa Ahmed. Today, I will be speaking on Count 1 of the indictments, the common plan or conspiracy. The Nazi Party, also known as the National Socialist German Workers' Party, initially was a core of the common plan or conspiracy, and the Nazi Party also became the instrument for the carrying out the goals of the conspiracy. Defendants accused of conspiracy are charged with planning and participating in the events leading up to the Nazi takeover and the establishment of dictatorial control. The defendants are charged with conspiring to take complete control of the German government, eliminating all resistance and opposition, and establishing a dictatorial totalitarian regime controlling a single-party state. The indictment alleges that the defendants, as part of the conspiracy, set out to take over the German government through legal methods supported by terrorism, such as the creation and use of Die Sturmabteilungen, also known as the SA, which used violence. Once in control, the indictment alleges that the defendants used their control to facilitate the execution of other crimes, including the planning of an aggressive war. Specifically, defendants indicted on count 1 are charged with planning and waging a war of aggression, which was in violation of international treaties, agreements, and assurances. The indictment charges that the defendants conspired to violate the Treaty of Versailles by secretly engaging in rearmament. The conspiracy charge includes the training of military personnel, the production of munitions, and the building of an air force, all in violation of the Treaty of Versailles. The indictment also includes the accusation that the defendants reoccupied and fortified the Rhineland. The defendants are accused of planning an aggressive war to invade other nations in order to expand German territory, with the goal being Lebensraum, meaning the immigration of Germans into occupied territory. The charges of conspiracy also include planning of war crimes in violation of the customs of war established in the Hague and Geneva Conventions. The conspiracy also embraced the planning of crimes against humanity within Germany and occupied territories. These crimes included murder, extermination, enslavement, and deportation against civilian populations before and during the war. As participants in the conspiracy, those found guilty may be held responsible for the execution of all actions related to the common plan. The defendants charged with count 1 of the indictments include Hermann Goering, Karl Donitz, Walter von Schirach, Rudolf Hess, and Erich Raeder.
The court now recognizes Kinsey Irwin, Justice representing the government of the USA, in justifying count 2, crimes against peace, for which the defendants may be tried for today.
Good morning. I'm Justice Kinsey Irwin, representing the USA, along with Associate Chief Justice Lauren Altman and Chief Justice Reese Benford. Crimes against peace is the second of the 4 indictments defined by the Charter. 4 of the 6 defendants on trial today, Hermann Goering, Karl Donitz, Rudolf Hess, and Erich Raeder, are charged with crimes against peace. Crimes against peace is closely linked to conspiracy, or the planning and initiation of waging wars of aggression against other countries. Implementing the plan involved the breaking of a long list of international treaties that were put in place to protect countries and their civilians, especially after the First World War. The development of technology from the Civil War to World War I made it evident that the magnitude of loss that would result from modern warfare would be infinitely more disastrous than in the past. The development of weaponry was in direct correlation with the likely increase in death of civilians. As a consequence, there was such an urgent need to preserve the peace in the years between the wars that the desire for peace was enshrined in the Kellogg-Briand Pact, officially known as the General Treaty for the Renunciation of War, as an instrument of national policy. Following Hitler's rise to the position of Chancellor and his consolidation of power after the death of President Hindenburg, the German economy was gearing for war, utilizing the money that they had to increase their technological warfare. As a result, countries were at greater risk because of the advanced warfare. Countries sought to protect themselves. Treaties were their main shield, and when violated, said countries were put at great risk. The domino effect of breaking treaties in opposition to the spirit of Kellogg-Briand became immediately apparent after the attack on Poland in 1939, as 7 countries fell victim to Nazi aggression in 9 months. The Nazi regime's initiation of war against these countries led to the disastrous events that followed. Breaking of these treaties is the cause of death of millions of innocent civilians and millions of soldiers. Defendants charged with crimes against the peace are accused of instigating these actions that violated countless treaties designed to prevent war and brought the world into disastrous global war, a second time in 2 decades.
The court now recognizes Charlie Leonard, Justice, representing the government of the United Kingdom and justifying count 3, war crimes, for which the defendants may be tried for today.
Good morning. I'm Justice Charlie Leonard, representing the United Kingdom alongside Justice Ava Horwitz and Chief Justice Sophie Schermunker. This count, as defined in Article 6 of the Charter, charges defendants with war crimes or violations of the rules of war primarily established by both the Hague and Geneva Conventions. More specifically, this includes the conscription of civilian labor, such as the conscription of 3,000 Luxembourgers in 1944, and deportation for slave labor and for other purposes of the civilian populations of and in occupied territories, such as the deportation and enslavement of 750,000 Czechoslovakians throughout the war. In addition, it includes the murder and mistreatment of prisoners of war, which is described more in depth in the Geneva Convention, of other members of the armed forces of the countries with whom Germany was at war, of civilian populations in occupied territory, such as the murder of thousands of children in the Latvian SSR, and of persons on the high seas. Also, it includes the plunder of public and private property, such as 55,100,000 in francs from the state of France, the exaction of collective penalties such as fines against the Jewish population, and the malicious destruction of cities, towns, and villages, and devastation not justified by military necessity, such as the destruction of Skela, Greece in August of 1941. Finally, it includes the killing of hostages, such as the tens of thousands of hostages that were executed in France, Holland, and Belgium, and forcing civilians of occupied territories to swear allegiance to a hostile power, such as the incorporation of youth from the lower and upper Rhineland into the Hitler Youth. Defendants charged with war crimes include Hermann Goering, Karl Dönitz, Rudolf Hess, and Erich Raeder. Thank you.
The court now recognizes Rogan McClendon, Justice, representing the government of the Soviet Union in justifying count 4, crimes against humanity, for which each defendant may be tried for today.
Good morning. I'm Justice Rogan McClendon, representing the USSR alongside Ula Chachio. Today I will be speaking on count 4 of the IMT indictments, which is crimes against humanity. All defendants, Hermann Goering, Julius Streicher, Alder von Schirach, Erich Raeder, Karl Dönitz, and Rudolf Hess, will be charged under this count. According to the Charter, Article 6 states that crimes against humanity is, quote unquote, namely murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during the war, or persecutions on political, racial, and religious grounds, and execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the domestic law of the country were perpetrated. Another way to rephrase this is to commit gruesome crimes that should be known common knowledge not to do. Although the charter was not made until after the war, there were already common practices and laws built around this indictment. One of which was malum in se. This is a Latin phrase which is built around the inhumane behavior that is inherently wrong by nature. Examples like the 60,000 Jews that were shot on the island of Divina near Riga, the 70,000 Jews that were exterminated in Yugoslavia, the 60,000 Jews that were shot at Kiev and Dnipropetrovsk, and the 30,000 Jews that were shot at Sarny were all clear examples of clearly gruesome and inhuman acts that all file in violation of this fourth indictment. Thank you.
The lead defense attorney, on behalf of all 6 defendants, has prepared evidence and statements in order to challenge the legality of this tribunal, along with the 4 indictments on which the defendants are being accused, which were stated and described previously by my fellow justices. We will begin this hearing with a motion on behalf of all defense, presented by lead defense attorney Coco Schuster. Please approach us.
Good morning, Your Honors. Ladies and gentlemen of the court, I stand here and ask you today, why are we willing to sit here for hours and abide by a trial that is legally unjust? Why are we willing to abandon the laws by which we abide to achieve justice for a case of symbolic retribution? The Nuremberg trials should not take place because they are a form of victor's justice against the German people on behalf of the Allied nations. Evidence will show that the German defendants tried before you today are being charged on several counts that have no precedent whatsoever under international law, as well as offenses that have long been considered common practices. The Germans who are sitting here today are being tried for acts that every nation who has engaged in war has committed without facing prosecution at the level the Germans are facing. These trials are occurring under an unfair precedent with a predetermined outcome, and carrying them out would threaten the legitimacy and reliability of the court. Ex post facto. The Nuremberg trials are legally inconsistent and illogical because indicting the Germans for crimes against humanity is an example of ex post facto law. This term corresponds to a law that retroactively changes the legal consequences of actions that were committed before the enactment of said law. In a multitude of countries, including the United States and France, an ex post facto charge is against the law. According to Article 1, Section 9 of the U.S. Constitution, No bill or attainder or ex post facto law shall be passed. Document 1. If the act of punishing someone for an ex post facto charge is against the US Constitution, how are the Nuremberg trials, which is an international trial, operating impartially if the defendants are being tried with no set international precedent? The term genocide was only invented after the actions of the German defendants, giving the prosecution the opportunity to form and manipulate their claims based on the Germans' exact actions, encapsulating the precise faults of the Germans into a crime and then trying them for it. In no way is this defense claiming that the actions of the Germans should be ignored, that the legitimacy of the international court is threatened if such a trial that breaks legal bounds is held. This case should not be an exception for the court, because if the tribunal allows ex post facto justice, it would set a dangerous precedent for future generations. Nulla poena sine lege. Similar to the previous statement regarding ex post facto, the charges the Germans are being indicted for go against the principle of nulla poena sine lege, meaning no crime, no penalty without law. This principle warrants that a person can strictly face criminal punishment for an act that was criminalized by law before the performance of such an act. The charges listed in the indictments were not crimes at the times the Germans committed those acts. So how were the defendants supposed to know that their actions were punishable? It goes against the rule of law to prosecute a person for criminal conduct when there was no law prohibiting the action. Giving some nations the ability to create ex post facto laws and punish others for breaking them gives these nations extensive power over others. The Nuremberg trials will create a paradigm in which nations with more power can punish other nations on their own agenda simply by creating a law to do so. This unfair power dynamic will inherently cause violence between nations, as they will punish each other whenever they please, likely leading to revolts and wars. This is simply not a logical price to pay for the sole purpose of holding a small number of Nazi leaders accountable, taking into account the damage it inflicts in the process. Additionally, we must consider the morals behind this issue. Is it fair for countries to punish each other at any moment they desire? This principle of nulla poena sine lege was created by the United States, the very force that would be causing harm to both Germany as a sovereign nation and the future of the legal system if these trials are held. My second point is that it is unjust for post-war consequences to be determined by the victors of the war. The Treaty of Versailles, Document 2, was an agreement created by the victors of World War I and forced Germany and other Central Powers to take all the blame for the war. This treaty disrupted Germany's flourishing economic and political status by causing a loss of territories, reduction in military forces, and reparation payments to Allied powers. Germany lost 10% of its land, all its overseas colonies, 12.5% of its population, 16% of its coal, and 48% of its iron industry. Document 3. The treaty contributed to German political and economic instability that allowed for the formation of the Nazi Socialist Party just a year later. Just as soon as the Germans were beginning to recuperate from the effects of World War I, they were hit by an economic depression, resulting in chaos for the German people. As the circumstances in Germany grew worse and worse, radical right-wing political forces, the Nazis in particular, gained support by promising to reverse the humiliation of the Treaty of Versailles. With the onset of the Great Depression after 1929, financial unrest destabilized the already vulnerable Weimar government, consequently setting the stage for Nazi leader Adolf Hitler's fateful rise to power in 1933. It has been demonstrated that punishing Germany for losing the First World War directly caused an even more detrimental war, so why allow history to repeat itself? Castigating Germany for losing another war will possibly incite a third, more deadly world war. It can be inferred that by carrying out these trials, the International Military Tribunal would cause more harm on an astronomical level to the future of global peace and absolutely diminish the purpose of holding these Nazi leaders accountable. My next point is that if the Nuremberg trials are to be carried out, the verdict would be determined by political leaders of the very same allied nations who fought to torpedo the German Reich for years, an apparent and alarming conflict of interest. Not only are the members of the tribunal strictly on the winning side, but these leaders have deeply rooted biases against the German people and have repeatedly spread propaganda denouncing the Nazi Party and labeling the group as inherently evil. Leading up to the date of the trial, we have heard rumors that the Soviet Deputy Foreign Minister, Andrew Vyshinsky, made a toast to the defendants with the words, "May their paths lead straight from the courthouse to the grave." The defense asks the court if this allegation is true. If this comment was indeed made, members of the tribunal had already made up their minds on the verdict and future of the German defendants before these trials were even in motion, wholly contradicting judicial impartiality. The judgment of these potential jurors is hindered by their internalized resentment of the Germans, elucidating their inability to evaluate the argument with full clarity as the verdict of the trial has been predetermined. If the Nuremberg trials are held under premeditated conditions, the whole trial becomes illegitimate, as well as the integrity of the international law. What criterion did the Nuremberg trial set for the future of jurisprudence if we allow a trial to happen under these biased and disorderly conditions? In addition, it has been demonstrated that punishing a group for their actions does not always prevent future mistakes from happening, as there will always be extremists who are willing to do anything for their beliefs, no matter where they are from. My next point is, if other countries are allowed to perform these acts to a point of normalcy and face no extreme prosecution, how is it permissible that the German people are facing trials for actions that throughout history have been proven time and time again to be common, non-punishable, and widely acceptable? The Nuremberg trials are invalid and immoral because the defendants are being indicted for conduct that is considered common practice amongst many sovereign nations. The definition of common practices is the management techniques that are expected and treated as the default, whether the law permits them or not. As demonstrated throughout history, the acts of the Nazi Party is being tried for are not solely done by this individual group, but committed on a large scale globally by many different nations and organizations. These actions were not prosecuted on the scale of the Nuremberg trials, but instead were considered perfectly reasonable for other countries to perform. How are the Germans expected to know that following the precedent set by the Allied countries just to a larger scale was an exception for their sovereign nation when the exact same deeds have been equally exhibited internationally to a point of normalization? The German Reich treated the Jewish people in accordance with traditional standards and international sanctions. Some archetypes of these common practices in other countries include the following. During the South African War, also called the Boer War, the farms of Boers and Africans alike were destroyed by the British, with the inhabitants of the countryside rounded up and held in segregated concentration camps, often under horrific conditions. This resulted in non-combatant deaths of 26,000 Boer women and children, and an estimated range of 13,000 to 20,000 total concentration camp deaths. Document 5. The British people should not be attempting to prosecute the Germans for partaking in an almost identical practice as them. During a war, extreme measures must and will be taken, as demonstrated in British African history. The German people looked at this war, realizing that such actions of killing and imprisoning citizens are viable during times of threat. How is it acceptable for the British to do such a deed while the Germans are being so strongly reprimanded? In the case of Buck v. Bell in the United States, Virginia allowed for the sexual sterilization of people with mental illnesses and physical disabilities to promote the health of the patient and the welfare of society. Document 6. Before the procedure could be performed, a hearing was required to determine whether or not the operation was humane. The U.S. court found that this statute did not violate the Constitution, essentially legalizing this practice. In 1927, the United States Supreme Court passed the judgment that sterilizing Carrie Buck, a mentally disabled woman, was constitutional. Virginia passed this law for the betterment of their country and the future of their people, facing no repercussions whatsoever. Germany carried out similar policies with the law for prevention of genetically diseased offspring, enacted in 1933, which would serve as the grounds for what would later be labeled as eugenics. In the case of Plessy v. Ferguson, Louisiana enacted the Separate Car Act, which required separate railway cars for Blacks and whites, treating Black people and other minority groups like a second and subhuman race. Louisiana legalized and welcomed segregation as it was not considered unlawful discrimination. Document 7. Germany's Nuremberg laws were parallel to this ideology. In the case of the Dawes Act of 1887, the United States forced Native Americans to relocate to assigned reservations, stripping them of their land rights, as well as forcing Native tribes to adhere to federal rule instead of their own traditions. Document 8. This act authorized the federal government to break up tribal lands by partitioning them into individual plots, with the objective of assimilating Native Americans into mainstream U.S. society by annihilating their cultural and social traditions. This act contributed to the normalization of governments internationally treating their citizens contingent on their cultural and racial identity, as well as the relocation of such minority groups. During the Trail of Tears between 1830 and 1850, the United States government mandated the forced displacements of approximately 60,000 Native Americans of the 5 civilized tribes. As a result of the fear and resentment of Native Americans felt by white people, some officials in the early years of the American Republic believed that the best way to solve this issue was to simply civilize the Native Americans, annihilating their cultural and religious beliefs in an effort to make them as similar to white Americans as possible. Document 9. State governments joined in this effort to drive Native Americans out of the South by passing laws limiting Native American sovereignty and rights and impeding on their territory. The government forced Native Americans to vacate lands they had lived on for generations, causing large groups of Native people to make the journey to new Indian territory on foot with no food, supplies, or other help from the government. As a result of this government-initiated displacement, thousands of Native American people died. In the case of Korematsu versus United States of 1942, the US government required Japanese Americans to move into relocation camps as a matter of national security in response to the attack on Pearl Harbor. The US claimed that this measure of security would keep them secure from invasion. Document 10, insisting that the imprisonment of Japanese Americans in concentration camps was constitutional in times of national threat. The Nazis' precautions taken against the Jewish race were equivalent to that of the Americans' willingness to protect their country at all costs. In conclusion, this defense is not arguing that the defendants should walk free. Instead, that the Nuremberg trials would inflict detrimental harm to the German people and Axis powers on behalf of the Allied countries. These trials may potentially cause another cataclysmic war, as well as the tapered constitutionality of the International Court. These outcomes are not in any logical way worth the justice of holding a small number of Nazi leaders accountable in an illegitimate trial. However, if the court is not persuaded by the overall argument that these trials should not exist, I ask that you are willing to consider common practice as evidence and arguments within the individual cases that follow. Thank you for your time.
Lead prosecutor Miguel Fernandez has prepared a response. Please approach the bench.
Good morning. As part of the very first International Military Tribunal, the bare minimum that can be done by humanity is to hold these trials. After the illegal and barbaric actions of the Nazi Party were uncovered, it became extremely clear that crimes of this caliber are impossible to ignore. The list of these crimes include mass deportations, mass extermination, violation of international treaties, aggressive war, enslavement of civilian populations, mistreatment of prisoners of war, and other explicitly inhumane acts made by the Nazi Party. The defense will attempt to argue that these crimes are so ordinary during times of war they are fit to go unpunished. They have made the point that holding these trials is an unjust form of justice and will threaten the legitimacy and reliability of the court. In the case of previous wars, there have been somewhat similar acts committed, but it is factual that none could ever match the stature in which each of these defendants committed these crimes. While it is beyond doubt that these crimes will never be reversed and brought to full justice, holding these trials will engrave a bold standard into the human mind. Holding these trials will make it clear for the rest of time that crimes like these will not go unpunished. The first International Military Tribunal will not be the pinnacle of human justice, but it will be the necessary first step society must take to ensure crimes of such villainous nature don't step foot in our history again. The point is made by the defense that the crimes committed by the defendants are those of regularity. As similarly introduced during the introduction, similarities between the crimes committed by the defendants and other wrongdoings throughout history may be present. However, that must not be an adequate reason to not hold these trials. The crimes committed by the defendants throughout the duration of the war are by no means ordinary. It must be made evident that the crimes committed led to the deaths of over 6 million people. These crimes weren't the result of an ordinary occurrence, but of the largest organized mass murder program since the existence of humanity. A program forged by the defendants even before the start of the war. The existence of this program was not a necessary action taken in order to defend the German Reich. The crimes committed by the defendants have no correlation with a common practice, neither would they have directly benefited the nation. The defendants clearly went beyond any necessity to commit these crimes. The mission of the defendants was simply to lead to the eradication and total annihilation of the Jewish race across the European continent. The defense has presented the case that similar deportations to those the Jews across Europe experienced were made within the United States in the form of the Japanese internment camps. During World War II, the United States brought the Executive Order 9066 into effect. However, the argument the defense presents has many flaws. Through the Executive Order, Document 3, the United States deemed it necessary to exclude people of Japanese descent from the rest of the population. The order is partly justified by the fact that the Japanese Imperial Navy deliberately attacked the United States without a proper declaration of war being in place. This makes the order partly necessary as the circumstances with Japan were those of incredible distrust. Furthermore, the United States is likely to revert and apologize for their actions in the near future. The simple cause of this being, there have been multiple cases in the Supreme Court challenging the order in those of Korematsu versus United States, Minoru Yasui versus United States, and Hirabayashi versus United States. The defense makes the point that the acts committed by the defendants go in line with the regular practices of the time. They present various pieces of evidence, including the Buck versus Bell and Plessy versus Ferguson cases. It is true that correlation between the cases and acts the Nazis committed exists. However, the correlation only exists to a certain extent. The Buck v. Bell and Plessy v. Ferguson cases might show that the US has excluded some people from their society. But these common practices have never reached the heights of the Nazi program. The bare minimum of Nazi acts fall in line with practices of the time, as their program went to the extent of the extermination of the Jews. No common practice of the time can ever match the extent to which the Nazi plan attempted to achieve. The defense has attempted to present the argument that some of the indictments presented by the prosecution fall into the category of ex post facto. They also present the evidence that the US Constitution forbids the use of an ex post facto law. The term ex post facto means a law changing the legal consequences of an action after the action was taken. By presenting this argument, the defense is trying to imply that they were not aware of any wrongdoing. The reality behind it is that all 4 prosecuting nations have a law against murder. According to US code and law, murder is the unlawful killing of a human being with malice aforethought. The prosecuting nations aren't trying the defendants for ex post facto laws, but off of laws that already exist. It is evident that there weren't any pre-existing laws on mass genocide, but it is also extremely evident that the majority of nations across the globe have a law against murder. The truth behind this ex post facto fallacy is that the defendants aren't being tried for laws they weren't aware about, but for violating already existing laws to such a point of extremity that a new definition was deemed necessary. The goal of these trials is not only to try the defendants, but allow both sides to be able to defend and prosecute each other in a fair trial. The idea that this trial will not be just is erroneous. There is no existing factual evidence that proves that defendants are not being provided with a fair trial. The terms for the fairness of the trial is provided in Article 16 of the Charter of the International Military Tribunal, Document 2. The defendants are provided with every opportunity to be able to defend themselves in a fair court. The defense presents the point that a trial would not be the right way to serve justice, and it is not a proper form of judgment. Let the defendants be reminded of the fact that these trials are not being held in order to take revenge on the defeated side of the war. The prosecution would like to leave a stamp on history by punishing the Axis powers in the manner of executing any possible Nazi member would be to take revenge on the Nazi cruelty by using the same violence and cruelty they used to commit these crimes. The point of these trials is to indicate to the world that these crimes will not go unpunished, and to set up the world for a new era of peace and restructuring, and not to take revenge on the losing side. The International Military Tribunal is not an effect of victor's justice. Neither the United States, Great Britain, France, nor the Soviet Union directly benefit by holding these trials. The trials are not being held in order to take revenge on the Axis powers or to gain any tangible benefit. Like expressed before, these trials are being held to set the world into a new era of peace. The failure of the Treaty of Versailles after the Great War to maintain peace is one of the reasons why the trials are being held. The emphasis on these trials is not to punish the German people or to have them suffer in the same manner they did after World War I, but to ensure the world has a sustainably peaceful environment for decades to come. It is evident that taking revenge on the defeated side would be just as catastrophic and devastating as the Treaty of Versailles was. In this case, the trials will be an excellent example for future generations to maintain peace and heal from the wounds caused by the Nazi Party during World War II. Additional Nazi crimes. It is beyond the realms of doubt that the genocidal crimes committed by the Nazi Party are undeniable. The perpetrators to these crimes not only involved themselves in the execution of such crimes, but furtherly into extensive planning and organization of such violations. As it must be restated, the Nazi transgressions were not a result of dire necessity. Neither would they have directly benefited the nation. The crimes were a result of deeply rooted racial ideological hatred towards the Jewish people. The Nazi Party did not target the Jews because of a direct threat, but simply because they did not fit into their vision of a racially pure people. The spread of this belief and the major popularization of the Nazi Party and its ideals was when the crimes committed truly came into the domain of possibility. From this point on, the Nazi Party would launch a long-term project in which the final goal would be the annihilation of the Jewish people across Europe. One of the first steps taken by the Nazis in their aims to achieve the extermination of the Jews was to strip Jews of their rights. This was achieved by the Nazis through decrees made official by the law, Document 4. In decrees such as these, Jews were stripped of their basic rights, an example being the ability to vote or the right to hold public office. The Nazis also took advantage of their order of protective custody, Document 5, in which they were granted the ability to arrest anyone who they felt were a threat to the state. It is important to note that the Jews did not pose any direct threat to the Nazi Party. Many times they would be arrested simply for being Jewish. The second major step the Nazi Party took was in attempting to identify and then deport many Jews into the ghettos, which are secluded parts of the city where many Jews were forced to live. These ghettos had appalling conditions and were one of the last steps in the Nazi plan before the concentration camps. The conditions of these ghettos are specified in a report made by General of Police Katzmann to General of Police in the East, Document 6. Furthermore, a report made by SS Major General Stroop, Document 7, specifies how in some cases there were even up to 6 people who lived per room in these ghettos. The final step before extermination was that of forced labor. The Nazis wanted to get the most out of the Jewish people before setting them up for extermination. The labor of the Jewish people would help the Germans in their war effort. Further detail on forced labor is given in a report by General of Police Katzmann to Kruger to General of Police in the East, Document 8. It is evident that the Nazis wished to exterminate the Jews while it is also evident that they exploited them for their own war effort as well. After the previous steps mentioned were finalized, the Nazi Party's high-ranking leaders made a final plan that would be known as their, quote, final solution in the Wannsee Conference. The final solution was the term the Nazis would use to refer to their plan to exterminate the Jews, and it was their, quote unquote, solution to the Nazi Party's Jewish question. Throughout the duration of these steps, it is clear that the Nazis had laid down a plan for these crimes and knew exactly what they were doing. The Wannsee Conference was the final green light for the extermination process to begin, document 9. Once the final green light was given by the Wannsee Conference, the extermination process would begin. The Jews would now begin to be transported from the ghettos to concentration camps. The grueling details and wretched conditions of these camps are specified by the Polish government commissioner in document 10. The Jews would be put into incredibly cramped cars on the way to the camps, followed by the men being separated from the women and children or those who couldn't work. From this point on, those classified as weak or not fit enough to work were sent to immediate extermination in gas chambers. Those who could work were to be exploited for work and live under grueling conditions until it was decided that they too would start being exterminated. This program, fueled by cruelty and evil, led to the deaths of over 6 million people of Jewish descent and nearly annihilated the Jewish population in mainland Europe. Lastly, the idea of aggressive war must also be addressed. The defense makes the claim that holding these trials will only result in another world war. They have made the point that these trials will have the same effect as the Treaty of Versailles did after World War I. The truth being ignored by the defense is that allowing the Nazi criminals to roam free would be more disastrous than these trials could be. It must be made clear that the vision of the Nazis was to initiate war, so to speak about the violent effects a fair trial could have is an incredible fallacy. It must be reminded that the Nazis were capable of violating numerous treaties in order to initiate war. The Nazis violated countless terms within the Treaty of Versailles, document 11. They also conducted invasions against neighboring countries such as Austria, Czechoslovakia, and Poland that violated the Treaty of Versailles. The Nazis also violated their non-aggression pact with the USSR, document 12, by invading them just 2 years after the pact was signed. As made clear by their intent on initiating war, the vision of the Nazis is not to keep the world at peace, but to engage the world in countless years of violent conflict. Overall, the Nuremberg trials is nothing less than a necessity. The defendants have committed crimes to such an extent they are unable to be ignored. If the largest mass murder program in the history of humanity is allowed to go unpunished, we are setting a precedent for future generations that crimes of this caliber are acceptable. It is not being asked to take revenge on the Nazi Party by violence or mass executions, but to be able to execute a fair trial in which the instigators of these crimes are able to be prosecuted legally and the defendants are granted the opportunity to defend themselves. Throughout 12 years, the Nazi Party has taken on an incredible program of aggression, which saw them violate countless treaties, engage in multiple wars of aggression, and conduct the largest mass extermination program in human history. The crimes the defendants are being tried for are no ordinary crimes. They are crimes that have never before been witnessed at such an extent. If we miss the opportunity of trying these criminals, we will miss the opportunity to set a norm that crimes like these are unacceptable. If we miss this opportunity, we will let the instigators of the largest murder program in history roam free without the slightest attempt to prosecute. If we miss this opportunity, we will set the future on track for future generations to experience atrocities like these time and time again. And that is why it is beyond necessary that these trials are held as planned. Thank you.
The court would like to ask clarifying questions to these attorneys before reaching a verdict. Defense, please approach. You're arguing that the defendants cannot be tried for genocide because it is a new legal standard, but genocide is generalized murder, and both murder and conspiracy to commit murder are pretty widely accepted as crimes. So what is your justification for arguing that defendants cannot be accountable for them?
The the term genocide was invented after the actions and the things the defendants are being tried for. The term genocide completely encapsulated all of the actions of the Germans, not strictly murder, but created a new definition and then tried the Germans for the exact actions that they committed by creating a new law that tries the Germans, while a new term for murder. It gave the term genocide created a new term and tried the Germans for a new crime that did not exist before and encapsulated the actions of the Germans into this crime.
In a war that encompassed almost the entire world, who is going to be an unbiased judge of the accused or a better candidate than the justices sitting here today?
The defense believes that while the judges who are on this tribunal have biased opinions, especially the quote I shared about the about Deputy Foreign Minister Andrew Wyszynski, that is a clear conflict of interest as he clearly and explicitly shares his biased opinions towards the Germans.
Regarding the issue of common practice, does the existence of past crimes by other parties justify letting people today evade prosecution for their crimes?
The defense believes that if the Germans are being tried for the crimes that they committed, that it is unfair for other nations who committed the same crimes, just to a different scale, to walk free. So I believe that if the Germans are being tried for their crimes, then every other nation should be tried for the crimes that they committed.
Thank you. You may be seated. Prosecution, please. In light of acts of genocide and eugenics by the Allied powers, how do you justify targeting the Nazis for accountability when some of those responsible in the Allied countries have not been held accountable?
It is true that the Allied powers have committed some of the acts, but the Nazi Party went beyond those common practices of the time to such an extent that they planned the extermination of those people, not only eugenics.
Defense, can you first mention one more time?
Regarding the statement created by the Soviet Attorney General, do you believe that all justices sitting on this panel representing multiple Allied countries hold bias, or only the Soviet justice?
I believe that while the defendant, Andrew Wyszynski, made this comment and was indeed caught in his actions of his bias, it is very possible that any of the defendants who are on the tribunal today, because they are members of the Allied countries, have internalized biases towards the German peoples, but just have not explicitly made quotes about it.
Thank you. You may be seated.
The tribunal will now take a short break while the justices begin deliberating. Thank you.
All right.